Michael T. Dixon. Case number is 20CR0201. And my apologies for the late start, but we had to do some substitution of jurors due to some problems. And so I believe at this point we are ready to start. And I think the first thing we need to have done is have the clerk of courts, Ms. Edwards, administer the oath to the jurors.
Please all rise, please, and raise your right hand. Do you swear or affirm that you will diligently inquire into and carefully deliberate all the matters between the state of Ohio and the named defendant, Michael T. Dixon? And do you swear or affirm that you will do this to the best of your skill and understanding without bias or prejudice, so help you God? I do.
Right. Thank you. You may be seated. Thank you, Ms. Edwards. All right. So at this point, the jury has been impaneled. 12 jurors and 2 alternates. And court at this time will read you some preliminary instructions before we receive the opening statements from counsel. Now, ladies and gentlemen, it's important that you be fair and attentive throughout the trial. Do not discuss this case among yourselves or with anyone else. Do not permit anyone to discuss it with you or in your presence. Do not form or express any opinion on the case until it is finally submitted to you. More difficult for you to understand is that you may not discuss the case among yourselves until it is finally submitted. You will receive the opening statements, the evidence, the arguments of counsel, and the law from the court in that order. It would be unfair to discuss the case among yourselves before you receive everything necessary to reach an informed decision. You must explain this rule prohibiting the discussion of the case to your family and friends. When the trial is over, you will be released from this instruction. At that time, you may, but are not required to discuss the case and your experiences as a juror. Until that moment, you must control your very natural tendency to discuss the case both here and at home. The court instructs you not to converse with the attorneys, parties, or witnesses during the trial. Likewise, the participants in the trial must not converse with you. If anyone should attempt to discuss the case with you, report the incident to the court or to the bailiff immediately. You may not investigate or attempt to obtain additional information about this case outside the courtroom. It is highly improper for any one of you to attempt to do so. You are instructed not to read, view, or listen to any report in the newspaper, radio, or television on the subject of this trial. Do not permit anybody to read or comment upon it to you or in your presence. News reporters are not in the courtroom throughout the trial, so their impressions are incomplete and at times inaccurate. You must consider and decide this case only upon the evidence received in the courtroom. If you should acquire information from an outside source, you must disregard it in your deliberations. In addition, you should report the outside source of information to the bailiff or to the court at your first opportunity. You may not receive information about this case from any other source other than what you are presented in this courtroom concerning the case. That means you do not Google any party, lawyer, or court personnel in the case. Do not conduct any research whatsoever on the internet about the case or the parties or the facts involved in it. You may not blog about the case or events surrounding the case or your jury service. You may not tweet about anything to do with the parties, the events, or facts in this case or your jury service in this case. Do not send any emails to anybody conveying your jury experiences or information about the case. In the jury room, you are not to use your cell phone at recesses or at lunch to call anybody to ask questions about the issues in the case or to report the facts about the case. You may not use Facebook, YouTube, or any other social network on the internet to discuss your jury service or issues in the case or people involved in the case, including the lawyers. Do not attempt or recreate by experiment at home any evidence which you hear as testimony in the courtroom. Failure to abide by these instructions could result in you being found in contempt of court or cause the trial to end prematurely. The procedure for the trial is controlled by statute. First, the counsel for the state, the prosecutor, outlines what he expects the evidence will be. Counsel for the defendant may then state what his evidence will be. These are opening statements and they are not evidence. They are a preview of the claims each party designed to help you follow the evidence and understand the case as it is presented. In the presentation of the evidence, the state proceeds first. Thereafter, the defendant may offer evidence and the state may offer rebuttal evidence. The trial itself concludes with the arguments of counsel and the instructions of law by the court. Thereafter, you will deliberate upon your verdict. Before we hear opening statements of counsel and begin to take evidence, I believe it would be helpful for you to have some preliminary instructions to follow in listening to and considering the evidence which you will hear in the case. Later, after you've heard all the evidence and closing arguments of counsel, I will give you further instructions covering additional law to which you are to follow in the case. It is the duty of the judge to instruct you in the law, and it is your duty to follow the law as I will state it to you both now and at the conclusion of all the evidence. First of all, it is your exclusive duty to decide all questions of fact submitted to you. In connection with this duty, you must determine the effect and value of the evidence. You must not be influenced in your decision by sympathy, prejudice, or passion toward any party, witness, or attorney in the case. If in these instructions or instructions which I will give you at the conclusion of the evidence, any principle or idea is repeated or stated in any varying way, no emphasis thereon is intended and none may be inferred by you. Therefore, you must not single out any particular sentence or individual point or instruction and ignore the others, but rather you are to consider all the instructions as a whole, and you are to consider each instruction in relation to all the other instructions. The fact that I give you some of the instructions now and some of the instructions at the conclusion of the evidence has no significance as to their relative importance, nor has the order which I give you the instructions. The attorneys for the parties will, of course, have active roles in the trial. They will make opening statements to you, question the witnesses, make objections, and finally will argue the case as a last step before you hear my final instructions and commence your deliberations. Remember that the attorneys are not witnesses, and since it is your duty to decide the case solely on the evidence which you see or hear in the case, you must not consider as evidence any statement of the attorney made during the trial. There is an exception, that is, if the attorneys agree to any fact. Such agreement, stipulation, or admissions of fact will be brought to your attention, and you may then regard such fact as being conclusively proved without the necessity of further evidence on such facts. If the question is asked and an objection to the question is sustained, you will then not hear the answer, and you must not speculate as to what the answer might have been or as to the reason for the objection. If an answer is given to the question and the court then grants a motion to strike out the answer, then you are to completely disregard such question and answer and not consider them for any purpose. A question in and of itself is not evidence and may be considered only by you as it supplies meaning to the answer. Any fact in this case may be proven by either direct or circumstantial evidence. Direct evidence means exactly what the name implies, that is, it is evidence which directly proves a fact without having to infer the fact from some other fact. Direct evidence is usually the testimony given by a witness who has seen or heard the facts to which he testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence, on the other hand, is proof of facts by direct evidence from which you may infer a fact in question. For example, if the question of fact in a given case is whether or not Johnny ate the cherry pie, testimony by a witness that he saw Johnny put the pie in his mouth and eat it would be direct evidence of such fact. However, if a witness testifies that he arrived in the kitchen only to see Johnny standing there with an empty pie tin in his hand and cherry pie on his face, would be circumstantial evidence of the fact that Johnny ate the pie. The law makes no distinction between direct and circumstantial evidence as to the degree of proof required, and the facts may be proven by either type of evidence or combination of them. Each is accepted as a reasonable method of proof, and each is respected for such convincing force as it may carry. As jurors, you will have the sole and exclusive duty to decide the credibility of the witnesses who will testify in the case, which simply means that it is you who must decide whether to believe or disbelieve a particular witness and how much weight, if any, to give the testimony of each witness. In determining these questions, you will apply the tests of truthfulness which you apply in your daily lives. These tests include the appearance of each witness on the stand, his manner of testifying, The reasonableness of the testimony, the opportunity he had to see, hear, and know the things concerning which he testified, his accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because it was given under oath. You may believe or disbelieve all or any part of the testimony of any witness. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of such issue. Rather, the final test in judging the evidence would be the force and weight of the evidence regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. Also, discrepancies in a witness's testimony or between his testimony and that of others, if there are any, does not necessarily mean that you should disbelieve the witness, as people commonly forget facts or recollect them erroneously after the passage of time. You are certainly all aware of the fact that two persons who are witnesses to an incident may often see or hear it differently. In considering discrepancy in a witness's testimony, you should consider whether such discrepancy concerns an important fact or trivial one. If you conclude that a witness has willfully lied in his testimony as to a material fact, you may distrust all of his testimony, and you would then have the right to reject all of his testimony unless, from all the evidence, you believe that the probability of truth favors his testimony in other particulars. During this trial, the jurors will be permitted to take notes. The court has provided you with a pen and notepad for your convenience. For many years, the practice of juror note-taking was discouraged because the taking of notes may distract your mind from the evidence that is being presented while you are busy taking notes. The other reason was that the best note-taker might have more influence on the other jurors than is appropriate. I suggest that you take notes when there is a pause in the testimony. Remember, each of you must individually determine the issues in the case. At the end of the case and deliberations, your collective minds will then reach a verdict. Please understand that testimony cannot be repeated nor the trial delayed to permit accurate note-taking. It is your responsibility to listen to the testimony. There is no requirement that you take notes. Please place your name on the front of the notepad. The notepads will be collected at lunch break and each afternoon by the bailiff at the evening recess. Your notes will then be redistributed to you when we reconvene. You may not remove the notepad from the courtroom. However, during jury deliberations, you may have your notes with you in the jury room. All notes are confidential and for the consideration of the jury only. After you have concluded your deliberations, your notes will be collected and destroyed. This concludes my preliminary instructions to you, and I hope that they will be of some assistance to you in listening to and considering the evidence. Please keep these instructions in mind as you listen to the evidence and statements of counsel. I may give you additional instructions during the trial. When the evidence and the closing arguments are concluded, I will give you additional instructions on the law, which you are to follow together with the instructions you have just heard and any given during the conduct of the trial. At this point, I wanted to note that the defendant is present along with his attorneys. I don't think I mentioned that earlier. All right, and the defendant's been present the whole time since the court started giving instructions. All right. At this point, counsel for the parties may have an opening statement. The opening statements of counsel are concise, orderly descriptions of each side's claims and defenses, and the evidence that counsel expects to produce in support of those claims and defenses. They are not evidence. Each side will address you once during opening statements. The state will go first.